Good afternoon, friends. Come on in to this live session. I'm going to be talking about exciting news regarding the immigration budget reconciliation process. I'm Latoya McBean Pompey, an immigration lawyer in New York, working with clients all over the world. Contact us at McBean Law to learn more about who we are, what we do, and how we help people. You may also follow me on Instagram at McBean Immigration Law, where I do more videos, live sessions, and some other things. The House Judiciary Committee is marking up the bill text right now. They've been at it all day. All day, the Republicans have been offering various amendments to the bill, and those amendments have been defeated. Okay, so what's going to happen next is this. After the House Judiciary Committee marks up this bill, there's going to be a conference or a meeting with the Senate on the Senate side to reconcile the Senate version versus the House version. And so they're going to have this conference, and ultimately, friends, the parliamentarian will still need to approve this. Okay, so there are some key steps that need to happen between now until this becomes final, before it becomes real. Keep this timeline in mind. This is what's being marked up right now by the House Judiciary Committee. Providing for reconciliation pursuant to S-Con Res 14, the concurrent resolution on the budget for fiscal year 2022. This is the committee print that came out just a couple of days ago, and today it's being marked up. The very first section jumps right into the pathway to lawful permanent status for key individuals. The first section deals with adjustment of status for certain people, okay? So this particular Section 1A focuses on the young people, dreamers. Okay, so who are dreamers under this, some call it amnesty. It really is an amnesty program, okay? So I'm going to refer to it as amnesty as well. So who is eligible under this amnesty? Someone who applies for adjustment of status. This is all about adjustment of status. This bill takes you directly to the green card. It is not a conditional residency or anything temporary or anything like that. No, this is lawful permanent residency. Okay, and the first section deals with dreamers. They have to pay a supplemental fee of $1,500. That is the fee under this section for dreamers. And they must also pass a security check, medical examination, and so on and so forth, the regular background security check that's required. They must have continuously been physically present in the United States since January 1st, 2021. So if you've been here since January 1st, 2021, you may very well be eligible for this. You were under 18 years or younger on the date that you entered the United States, and you've been here continuously. Okay, and then here are the educational requirements. You must demonstrate that either you have a record of honorable service in the uniformed services of the U.S., attainment or completion of at least 2 years in good standing of a program that led to a degree from a U.S. institution of higher education, or a post-secondary credential from an area career and technical education school. During the 3-year period immediately preceding the date on which you apply for adjustment of status, you must have a consistent record of earned income, okay, or enrollment in a program, an employment, current employment, or participation in an internship, apprenticeship, or similar training program. Okay, and I've mentioned that this first section, which is section 1A, focuses on dreamers, 18 or under when they came into the US. Part 2, or section 2A, focuses on essential workers. Now, guys, I must jump back on the screen and say this. The Democrats, they did exactly what they said that they were going to do here. Okay, so you have to understand that. They actually did come through for the categories of people who we've been talking about for the past several months. Dreamers, essential workers, TPS holders, and then those with deferred enforced departure, DED. Those are the 4 categories of individuals who this applies to. Okay, let's get to essential workers. You must have continuously been physically present in the United States since January 1st, 2021. Okay, that's huge. And then you must find yourself on this essential workers list and demonstrated that you have a consistent record of earned income in the U.S. as an essential worker during the period beginning January 31st, 2020 and ending August 24th, 2021. So you have to demonstrate that you were working in an essential job during that period of the pandemic. Okay, part three. Part three deals with TPS holders. TPS holders who have has continuously been physically present in the United States for not less than 3 years, and you're a national of a foreign state with a TPS designation that was designated around January 1st, on January 1st, 2017. So it's also very broad, okay? And I may skip through some of the language here. And you haven't engaged in any conduct that would now make you ineligible for TPS, okay? So certain crimes and some other things. Okay, Part 4, or Section 4A, applies to those with deferred enforced departure. You must have continuously been physically present in the United States for not less than 3 years, and you were eligible for DED as of January 20th, 2021. And you have not engaged in any kind of conduct that makes you now ineligible for deferred enforced departure. Now, so those are the categories of people. And I know you may have questions about who's an essential worker. Am I an essential worker? Am I, there's this determination of essential workers is exactly like, what I had been saying in consultations, and I may have said it to you publicly as well, live, or in other videos, but it depends on this list that the federal government has determined to be essential workers. It's based on a memo of essential critical infrastructure workers' ability, and this is a 23-page memo, which we will not get into, but this 23-page memo, I've shared this with you before actually in another video on essential workers, goes into many different categories of who our federal government considers to be essential. There's law enforcement on here, folks in education, food, agriculture, the healthcare industry, and some others, energy. Okay, so this is the list that this legislation is now looking to determine who is an essential worker. And I'm going to put a link to this memo somewhere here after I do the video. I'll add it to the post so that you guys can go and check this out for yourself. Now let's get into the very interesting part of this this bill. And it is, who is ineligible for this? Okay, what could you possibly do to make you ineligible for this amnesty program, which targets 8 to 10 million people? Okay, so, and this is what's been being debated all day on Capitol Hill. It's really focusing on this section. So those who are ineligible under this section, friends, are individuals who have committed certain crimes under our law. And let me just go through it with you, because the text of the bill simply says, well, you must be found inadmissible under paragraph 2, 3, 6E, 6G, 8, and so on and so forth of section 212A of the INA. So let's go through that right now. I have my little cheat sheet here. Okay, so who is ineligible under this? So paragraph 2 of the INA talks about certain crimes involving moral turpitude, those who have controlled substance violations on their record, and so on and so forth. Section 3, paragraph 3, I should say, talks about those who have security issues, those who have, been convicted of espionage, terrorism, and other serious security offenses. Paragraph 6E focuses on alien smuggling. 6G, student visa abusers. 8 focuses on those who try to evade our draft rules, okay? 10A, polygamists. 10C, international child abduction. 10D, unlawful voters. Now, if you've committed those types of offenses, this starts off by saying, well, you're ineligible, but there are waivers that are available, and we're going to get into the waiver section shortly. Now, others who are not eligible are those who have has not ordered, incited, assisted. Hold on a second. If you have participated in any form of persecuting others on the account of their race, religion, nationality, and other things, you're not eligible. If you must not have been convicted of any offense under federal or state law other than a state offense for which an essential element is the alien's immigration status, that is punishable by a maximum term of imprisonment of more than 1 year. So in other words, if you have any offense on your conviction, this is conviction, on your record of a federal or state law that is punishable by a more than a year in prison, you're ineligible, but a waiver is available. Or if you have 3 or more offenses under federal or state law, okay, that for which the alien was convicted on different dates for each of the 3 offenses and imprisoned for an aggregate of 90 days or more. This is very specific, okay? Very specific. Amendments have been shot down to make this, to make this a little more narrow, okay? And then let's get to the waiver section. So if you have any of these types of offenses or federal or state offense or conviction, that's more than a year, that maximum penalty is more than a year in jail, you might be saying, whoa, can I still do this? Well, there is a waiver section that says you can, okay? Because this section 2 says that you may apply for a waiver based on humanitarian purposes or family unity, or argue that granting you this waiver is in the public interest. And this waiver section, friends, applies to paragraph 2 of the INA, section 212A of the INA, and that's the crimes section, which includes crimes involving moral turpitude. It also includes controlled substance violations as well. Okay, so section 2, you may apply for this waiver if you have a drug offense, essentially. Okay, then also you may apply for those of you who have been accused of alien smuggling, which is a form of inadmissibility that I've spoken with a number of you about. Student visa abusers and unlawful voters. Those are the only four categories that of offenses, I should say, that are waivable under this amnesty. Okay, now let's keep going. Treatment of expunged conviction. I'm going to skip through some of this. Okay, let's talk about removal. For those of you who are in removal proceedings, or you have a final order of removal, or you have an order of voluntary departure, VD, this section applies to you, and it says that you can apply for this for adjustment of status as well, okay? You can apply for it. You simply have to request an opportunity to do so, to apply, and you must show that you're eligible for this relief. So if you're in removal, this is something that you can apply for and work with your lawyer on negotiating through prosecutorial discretion with ICE an opportunity to either terminate removal proceedings or something like that, or administratively close. It depends on your case, obviously. But if you're in removal or have a final order of removal or voluntary departure, you can apply for this. Okay, let's keep going. And then there's for children who are in removal, this allows them to apply to stay removal, so that they could stay here a little longer. Let's skip through this. Okay, so you might be saying, well, when does this take effect? Okay, the bill text says that this section shall take effect on the earlier of the date that is 180 days after this is enacted, or May 1st, 2022, whichever, is earlier, right? So that's the section on the amnesty program for Dreamers, essential workers, TPS holders, and those with deferred enforced departure. Okay, now, what else is in this? Because there are some additional things here. There's provisions in here that will address the backlog issue on both the family visa side as well as the employment base side by recapturing unused immigrant visa numbers. So that's in here as well. Then let's see what else. Let me scroll through a little bit here. Then the diversity visa. This bill would also allow, for those of you who lost your opportunity to actually get your immigrant visa because of executive orders or presidential proclamations, and those of you who weren't able to get your visa by the September 30th deadline of each fiscal year, well, this bill allows you winners of the DV lottery to get your visa, okay? Those of you who won in 2017, 2018, 2019, 2020, and 2021, this says that the visa should still be available to you, okay? And if you were denied for the visa because of because of the executive orders, as I've said, or because of restrictions or limitations on visa processing, visa issuance, travel, or other issues related to COVID and our public health emergency, you're eligible to get your visa. Okay, let's see. Then there's some additional language in here that allows for folks to apply for adjustment of status who have been approved, who have an approved I-130 or an approved I-140, but you can't apply for adjustment of status yet because you have to wait until your priority date is current and there's a backlog. Well, this allows you to pay an additional fee, a supplemental fee, to be able to apply for adjustment of status early. Okay, and so there's a supplemental fee for families. If you're in the family preference system, it's $1,500 supplemental fee, and then it goes all the way up to those who are EB-5 investors. They would pay a fee of $50,000 to be able to apply for adjustment of status early. Okay, so now let's see. I think that's... Let me just scroll down. And if you're enjoying this information, just give me some hearts and likes and comments. Okay, then there's some dollars in here for USCIS. $2.8 billion would be provided to USCIS to help them to adjudicate applications faster, more efficient, to address the backlog issues. So that's money to them. And then there's $2.5 billion for what they're calling community-based violence intervention initiatives. And that's really the crux of it. Okay, so as you can see, friends, this is the markup. This is not the markup version. This is not the markup version. This is the committee draft. The committee draft, a little dark there. There we go. This is the committee draft okay, of the the immigration portion of the reconciliation bill, which is being marked up today on the House Judiciary side. I'm going to obviously do another breakdown of the Senate version and obviously the final version after they have conference and after they do the conference and then put it out for a vote. Okay. Now, just to summarize, this provides lawful, immediate, it goes directly to adjustment of status for about 8 to 10 million people. And it has a very generous waiver section in there for individuals who have a criminal background, very generous section. Let's see what they do with that section on the Senate side. This is, it's open to people who've been here since January 1st, 2021. So it applies to a lot more people than we thought. So friends, let me know your thoughts below. Share this video with other people. Subscribe to my channel on McBean Immigration TV so that you'll be the first to get notice of my videos, unless you follow me on Facebook, in which case you are the first, like now. But for those watching the replay, follow me, subscribe on McBean Immigration TV. And so Claudia says, let's see what the House and Senate comes up with. Exactly. Well, you're seeing right now what the House came up with, and the final version, if there's a significant departure of what I've shared with you today, if there's a significant departure after the committee finishes the marking up process, I'll be sure to let you guys know the difference between what was actually passed out of committee versus, you know, what I shared today, this version. Like I said, a lot of amendments have been, are being offered today by Republicans, and it's based on party line. The vote-in is pure party line vote. How can we view this so we can take our time and read through what applies? I'll provide the links after this live session to make I'll provide both links, the links to the committee text as well as the Essential Workers memo, okay? Okay, let's see. Fan asked a great question. Does this lead to citizenship? It does. It does. Although citizenship is not mentioned in the bill text, I have to do a word search, but I didn't see that there. But it does lead to citizenship in 5 years, because once a green card holder has been a lawful permanent resident for 5 years, he or she is generally eligible to apply for citizenship after that point. How can one be an essential worker without a work permit? Well, you can be an essential worker. Like I said, this is an amnesty, right? So it forgives individuals automatically for certain violations, including unauthorized employment, if it's an unauthorized, and obviously it is an unauthorized employment for most people, but for some people it's not. For some people, they may have applied for asylum years ago and they have a work permit that they've been renewing, and they're an essential worker and they're just waiting for their asylum application to be decided upon, and they've been working and they're doing essential work. They're eligible for this as well. Okay, so, you know, it really depends. Trudlin says, please recap. I joined late. You'll catch the replay. You'll catch the replay. Okay, what about DACA? So the attempt here, Laverne, is to, when I talk about dreamers, really, you know, there's an attempt in this legislation to widen that pot. So it's not just, so DACA recipients, you know, they're going to be eligible for this as well. They're going to be eligible for this because this actually broadens it to people who came in when they were 18 and under, whereas DACA is a lot more restrictive with respect to the age requirements and some other things. Okay. Okay, so I'm going to jump off now. Please share this with other people. Thank you so much, friends, for being with me in the middle of the afternoon, and I will see you in the next one. Bye-bye.